Never cut what you can untie. A famous quote by Joseph Joubert. Good afternoon and welcome to the fifth episode of Me-Arcone Queing, proudly powered by the Institute for Alternative Dispute Resolution, an organization dedicated to resonating peace, rebuilding trust, that is dialogue, as the path to resolution. I'm your host, Sahil Yadav, a student from National Law Institute, University Bhopal, and an intern under Institute for ADR. It's an honor to guide you through today's discussion on ADR with a special focus on mediation. And before introducing our special distinguished guest, I would invite the founder of inADR, Dr. Deepika Saini, to guide us and welcome the guest. Ma'am is here.
हेलो दीपिका मैम।
हाय मीनाक्षी मैम, कैसे हैं आप?
बहुत बढ़िया।
Very nice. Thank you very much for accepting our invitation, and I would love to see you on board with us. And I think due to the paucity of time, I will not take much of it. So please, let's start. Thank you very much.
Yes. Thank you, ma'am.
Thank you, ma'am. Continuing. Today we have Miss Meenakshi Sood, who is practicing as an independent counsel before the Honorable Supreme Court of India, High Court of Delhi, and District Courts of Delhi. She started her career in 2009 with M.V. Kinney and Company. After working with them for 6 years, in 2016, she founded her own law chambers and set up her independent practice as a counsel. Moreover, her core areas of practice are civil commercial litigation and arbitration. She is presently representing private clients before the High Court of Delhi, Bombay, and Chandigarh, and Supreme Court of India. She is also a certified mediator of Delhi High Court Mediation Center, Samadhan, and has conducted various training on POSH in various companies and institutions. She has completed her Master of Law from Amity Law, Gurgaon, and has graduated in 2009 from Bharatiya Vidyapeeth University. In today's podcast, we'll be discussing about your experiences and lessons, and to engage a productive session with an ocean of knowledge and chain of skills developed over years. So, ma'am, with your permission, I would like to start with the first question. I want to know that you have practiced before the Supreme Court of India, the Delhi High Court, and the district courts as well. So how did your early litigation experience shape your approach towards mediation? What changed your mind? And how was the path from litigation to mediation? What was the view behind it?
Okay, so when I joined the mediation, because Samadhan comes up with the empanelment of mediator from time to time. Every after 2 or 3 years, they come up with the empanelments request, and then you need to fill those empanelment requests. You get interviewed, shortlisted, interviewed, and then you get selected and you undergo your training exercise.
Exactly.
When I joined, I had no idea, honestly speaking. I don't want to sugarcoat it. I had no idea what is mediation. I only had an idea, okay, it is a, alternate to the litigation procedure where the parties themselves, mediate, comes to a settlement. And well, of course, I had no idea that it can be actually pursued as a whole-time career as well. Well, I'm fortunate enough that I have, taken the right decision. I was fortunate enough that I got shortlisted, interviewed, and I, got, selected in the mediation panel. I have undergone the training as well. After the training, actually, the very concept of mediation got me to think that mediation can be and should be taken by all the parties who are there in the litigation. In fact, before going to a litigation, before, even thinking about suing the other party, it is a medium which every party should explore.
Absolutely.
So in my, what I can say is that, since I have practiced before Supreme Court, Honorable Supreme Court, High Court, and District Courts, I think that I have a deep appreciation of, both the strengths and the limitations of the, litigation, of our adversarial system. And therefore, I think that mediation now is the core and the best alternative to the litigation, to even, arbitration, if I can say. Every party should explore the idea of mediation first before heading towards the litigation. So the adversarial system actually has changed my mind and have given me much idea that the mediation can be taken and should be taken by the parties. So this actually shaped my thinking.
So can you recall the first mediation which you ever conducted, or arbitration, or any ADR?
Yeah, mediation. Yes, I still vividly, recall my first mediation. I was a co-mediator with a senior mediator, Sunil Mittal sir.
All
He's a
right.
senior advocate. And that was my first mediation with him as a co-mediator, because before you get enrolled as a full-time mediator, you need to undergo an exercise to be a co-mediator with the senior mediator, so that you can observe and no, it's like a training exercise for you. I still recall that matter when it was a matrimonial case, and the very first meeting, and I asked this to sir. In the very first meeting, we saw both the parties in an unsettling, this thing, in an unsettling situation. Both the parties were poles apart. One party, without judging their, with all due respect to their, emotions and judgments, but one of the party was not ready at all to go for the mediation, and they gave us an idea that we are only, exploring this possibility because someone neutral from the family has asked me. That's why I have joined. And the other party's claim were, tall claims. She was asking for a handsome amount. And I asked this to sir that, sir, is there, I mean, how do you see it? That this is the first meeting, and the parties have actually showed their intention of, one of the parties have showed his intention of not going for the mediation. He's all ready to litigation, all boost up for the litigation. How do you see the matter to go for these parties to go for a settlement? And sir told me that, Meenakshi, this is the first first meeting. You will see the shifting and the moving of the parties from a unsettling behavior towards a settlement. And it should be the endeavor of every mediator to actually analyze the parties and shift their positions from one to another. And I still recall that it was, I think we took 16 17 mediation exercises, 16 17 meetings. And in the end of the meeting, both the parties were ready to go for the settlement. Both the parties have actually settled their matter. And it was such a mesmerizing experience that it actually felt like that just a month before the parties were not ready, and now just after 16 17 meetings, we see a settlement. So I never imagined it. So I was very surprised. I think that was my first experience.
All right, that's pretty great and enriching, of course, with learning experiences. So as we see that the ground reality of India involves emotions, and when the both parties are having emotionally charged dispute, so how can a mediator be neutral and manage those emotions and make sure that emotions are not hurt with discussions and arguments?
You see, this is the first thing which they actually teach you, not only in the mediation exercise, also in your when you're graduating, taking your degree of law, because you need to be. I can understand that you're in litigation. You need to have, you are bound and you're lawyer to your client. You are bound by the instruction of your client. But in any case, sometimes we also, as a lawyer, we also see some cases where especially matrimonial cases or succession or inheritance cases are concerned. These are very sensitive. So in these cases, sometimes that your party is, your party is wrong, or your party is not very fair in dealing. But you need to control your emotion. You need to, because since you are bound by the instruction of your client. Similarly, in mediation as well. See, you need to see that you are a neutral unless and until you show the other person that you're neutral, there cannot be the other person or the parties in the mediation would not trust you at all. They will not open their heart. They will not come to the open discussions. So this is the first thing which you need to maintain. You need to control your emotion. You should know that how to control your emotion. This is one factor which I think is taken by in mediation as well as in litigation in both the exercises.
I agree, totally agree. So as you said that you have been a certified mediator at Delhi High Court Mediation Center, Samadhan. So what differences do you see in court annexed mediation and private mediation firms or companies, institutes which are present there?
You see, Sahil, in court-driven mediation, honestly speaking, I'll be very ruthlessly honest with you. In court annex mediation, parties somehow, just don't want to show to the judge that we don't want to go for the mediation. Whereas at the bottom of their heart, they know that they are only going just to, please the judge. They do not know that, you're not pleasing the judge. The judge has already explained to you that whether you settle your dispute or you don't settle your dispute, you will come back here. And, in case there's no settlement, you have your, rights, obligations, everything. You have all your rights to argue or whatever, do stuff like that. But the problem is that in order to please the judge, or sometimes the parties think, अरे नहीं नहीं अगर मना कर देंगे तो पता नहीं जज साहब क्या सोचेंगे हमारे बारे में. So this thinking actually is absent in a private mediation, because in private mediation the parties come with their free. There is no obligation. So if the party is choosing a private mediation, which means that the party actually wants to explore the possibility of mediation or settlement. Whereas in court annex, the attitude of the parties are very different. Sometimes both the parties are ready. Sometimes you see that the parties are just dealing, or one of the parties is trying to delay the matter, and that's why they have referred the matter into mediation. So in private, there is these things are absent.
Well, that is a huge difference. Apart from that, if you could change one thing about mediation in India, because we see in India and in other countries, there's a lot of difference how everything takes place. So what would be that one thing which you would change in mediation?
Well, I truly think that there should be a mind shift. There should be a shift in thinking the way people think about the mediation. Absolutely. Because what most of the people think is that it's, if you're going to a mediation, it's a weakness. Your case must be weak. It's considered as a soft option, whereas it is not a soft option. In fact, mediation is the only exercise which can actually give you the kind of solutions which the litigation or the arbitration cannot give you. Absolutely not. And I tell this, before going to, before starting any mediation exercise, in my open, statements, I tell the parties that, sir, mediation is the only, exercise where both the parties are at winning stage. No party would lose. Whereas in litigation, you never know what comes, next. So yes, there should be a shift in thinking.
Very true, very true. Well, so as we know that you have been practicing in various subject matters like consumer law, family law, commercial disputes. So not all kind of mediations are of one kind. They can be of different various subject matters. So is there a difference a mediator adapts to a method by approaching the subject matter because they are different? What would you say about
Absolutely. Absolutely. So as you see, as I told you, if you are dealing with a matrimonial, succession, or inheritance dispute, the matters, these are the matters which involves, these are the sensitive matter. It involves the relationship of between the parties. So when dealing with these matters, you need to be very soft. You need to be I'm not saying that we are not open to discussion. We are not giving an active hearing or active listening in other matters. But in these matters, the efforts are more in it. And if I'll tell you what the core difference is, in the family matters or in the matter where the relationship of the parties are involved, you need to tell the parties openly that, see, these are your rights and these are the obligation and these are the things which can go wrong. Whereas if you see the parties who are coming from a commercial litigation, you don't have to tell them. They already know their weaknesses.
Absolutely.
But because in matrimonial or succession matters, the parties' emotions are so charged up that sometimes they ignore the advice of a lawyer, of their own concerned lawyer. In these matters, when I would not say advice, but when the law is when the other third party or as a mediator is just giving you a brief idea about what are your rights or what things can go wrong and how many years it can take up, like in divorce cases, it of course changes the position. So whereas in commercial we only talk about figures. In matrimonial or succession matters, we can be very soft. We can tell the parties that especially in succession inheritance matter, you need to sometimes party just want to preserve their relationship, so you need to just awaken them that please, this is a wake up call for you, not for you, for your children, for the future generations. So yes.
Absolutely, I agree totally. So, as we know that personal and professional life, even if we try to separate, they are very much interrelated and depend on each other. So, interesting question, that what do you think is one skill that you can apply to your everyday life and also to mediation? What would you say about that?
My favorite mediator, Mr. JP Singh, when we had the opportunity of hearing this in our training exercises, he only tells us that there are many tools of mediation when you come into mediation. The first and the most important tool is active listening. This is the most important tool. The problem with our, I won't say the generation, but the problem, it's a human tendency. We don't hear the other party. We don't listen to the other party. We are always in a hush hush to answer their question or to keep our side of story.
Yes.
So in mediation, yes, you need to have a active listening. If one, sometimes I have felt that mediation can actually go wrong when the other parties feel that the mediator is not hearing you. See, mediator is not a judge. Of course, we are only here to bridge the communication gap between the parties. Ultimately, the decisions are taken by the party, the solutions are derived by the parties only. But the active listening can actually give an idea to the other person that yes, I have been heard. So this feeling of being heard is very important, and that's, I think, is the most important tool, which I think that we here I have at least started doing in my day-to-day life as well.
Sure. Well, my next question to throw is that now we know that how the GDP and the income and economy is going of India. What do you think, apart from litigation, can young law students go to mediation and find them as a enough sufficient financial source of income? Is it so, or is it just a sideline tertiary sector which is right now moving in a very gradual way? What do you think about it?
See, Sahil, with this Mediation Act of 2003, wherein the commercial, in commercial dispute or transaction first have to explore the pre-litigation mediation. I see a very good change in that. And since it's a progressive, it's a progressive exercise, I think in upcoming years, the young and budding lawyers can actually adopt it as a full-time profession. You can train yourself to actively be a private mediator if you're if you do not get a chance to enroll yourself or empanel yourself with some institution. Like we have institutional arbitration, we have private arbitrations as well. So same goes with the mediation as well. The another thing which I feel is that now there should be a full-time course in the colleges with regard to this mediation exercise. The young lawyers can actually have, like, you are interning with Deepika ma'am, it's a ADR institution. The people can actually, young lawyers can actually intern and promote awareness about the mediation. They can help, they can take workshops. It will serve two purpose. One, of course, you're making your career in a mediation this thing, and another is that when that's what I truly feel is that when you conduct a lot of workshop in a special sector like this, you are also making people aware about all these tools.
Absolutely. So now, if we see the skill set of mediation needed, we need negotiation techniques, we need active listening skills. We also require certain other skills like how to draft an agreement. Do you think that there are some other necessary things which are missing currently in today's generation, the upcoming generation, and they are to be specially focused in those courses which you talked about? What do you think about that? Do you think there are some other skills?
Well, I see, yeah. So what I see is this, like, and this is my personal view. See, I feel that the training which a mediator undergo in order to enroll or empanel themselves with any of the institution, we get a very general training. Okay, how to conduct a mediation. These are the skills. How to apply these skills. When there is an impasse, how you need to break that. Hold, caucus session and everything. So this exercise, which I feel is very generalized in nature. What I see is that what is missing is that we need to have a focused and a specialized mediation. So, for example, if I'm talking about IPR, so if you are training or if you're conducting mediation in IPR matters, I think there are some specialized tools and the skills which need to be applied by a mediator who is specialized in IPR mediation. So the specialization I feel is missing, which is high time I think should be done, because you see, one size can't fit all, right? Even if we talk about our arbitration or adversarial system, we have specialized lawyer. We do have general lawyer, but now the trend is to be of specialization. So why not in mediation, of course?
True. So if we take a particular example, for example, one of the skill required is to pitch in ideas or after facilitation of communication. Another is to pitch in ideas, creative solutions for the same. Now, what if one child or a person who's preparing to be a mediator is missing that or not able to develop that? For example, instance, there are two neighbors and they are fighting over some kind of dispute. Now, to pitch in ideas, creative solutions also need certain kind of, we can't chat GPT always. We can't use AI tools always. They are not that sufficient.
Absolutely.
So what suggestions would you give to them to develop this pitching in capability?
Well, I think you need to read and you need to be thorough with the concerned laws then. So, for example, you just talked about a dispute which can take a picture of this criminal law. So you need to have a hold of it. What does the recent law says? Not only the statutes, but also the recent judgments which is being delivered by the Supreme Court or High Court. I'll give you the best example of it. In matrimonial matters, we regularly see a trend shifting with regard to the Supreme Court or High Court judgment. There are certain directions, from time to time, which have been passed by the High Court. For example, in Rajni Gupta matter, the court came up that you need to file certain kind of, this affidavit is required irrespective of the fact whether the parties have a MOU or do not have a MOU. You need to have this affidavit to be filed. That becomes a direction, this thing in the matrimonial matters. So I'll tell you why. You may be very good in your in a field. So if a person comes to me and if I'm not a matrimonial lawyer, it's not that I would not be able to, adapt to the circumstances. It is not that I do not know anything about the Hindu Marriage Act. I may know about the Hindu Marriage Act. I may have a certain idea, and I can get an idea by reading the statute, by reading the judgments. But what is missing is that the recent law or the recent judgments delivered by the court and the directions in pursuance to those judgments, you would not be able to get an idea about it if you are not specialized in such a field. So as I told you earlier as well, that specialization is the key factor which is missing from the mediation. So that is the gray area where we need to pull our socks.
All right, all right. And again, I'm curious to know one more thing, that has it ever happened with you that you're conducting a mediation, you're expecting something to happen in a particular way, but it turned out completely opposite and changed the situation?
Well, I was a co-mediator, and I can't tell you the details about it. All I can tell you about is this, that I was a co-mediator in one of the IPR disputes, and I do not deal much in IPR. In fact, I have, except 2 or 3 cases, I have never done any IPR cases, and I was not aware about certain terms which needs to be taken care. It's not there in any of the statutes. Okay, only if you're an IPR lawyer you can get to you will know that, okay, these are the terms, these are the compulsory terms which needs to be there in the settlement agreement. If these terms are absent from the agreement, the other party, may actually, especially the employer, the one who give the license, can revive the dispute irrespective of the fact whether you have a settlement or not. So my co-mediator asked me to draft the settlement, of course, as a part of exercise. I drafted the settlement and I missed that point. So he asked me that, is this, are you okay with the settlement? Just put yourself in the shoes of the other party. Would you be signing the settlement? I said, yes, sir. I see nothing wrong in that. He actually explained me those necessary compulsory terms, mandatory terms, which needs to be there. So sometimes, and that's why, that's the point where I felt that, okay, I can deal with IPR laws, but of course, in order to draft a settlement agreement, you need to be very careful. You need to know that these are the mandatory conditions, these are the mandatory clauses which needs to be there. So of course you learn from your experience. Now I know, but then, as I told you, that that's why the specialization is required. And we are so blessed. That's why we have in Samadhan, which thing is actually missing from what I feel is missing from a private mediation. In Samadhan or institutional, I don't know, I am not empaneled with other institution, but in Samadhan, what happens is when you draft your settlement agreement, okay, it goes for approval to the approving committee. And we have senior mediators in approving committee who knows everything, who knows everything about all of, since they also there are 4-5 people in the approving committee and they deal with different fields of law. They know almost everything about these kind of settlement and what needs to be taken care in a settlement agreement, everything, stuff like that.
Agreed. All right. So once I remember that I was being taught about it, and I could very easily differentiate between arbitration and mediation, but I found difficulty in differentiating between negotiation and mediation. So can you help me with that? Can you tell about how can we actually, is it a subcategory or is it different than that? What is the case about it?
See, negotiation and mediation is, of course, in a way different, but in a way similar to each other. I'll tell you why. If you are talking about a commercial dispute, and the parties in a caucus session told me, "Ki ma'am, hum to itne mein settle karenge," okay, and then I take the consent of the parties. Aap kya bolte ho? Should I, just let your offer know by the other party or not? So in a way, if you see, a mediator is also negotiating with the other party, because I can either keep that figure with me and can ask the other party in another separate session and can ask him ki aap kya expect karo, tell me about it. So he'll say X figure and the other party has said Y figure. Now the only thing which is required to be done by me is to bridge that gap. Now, in order to bridge that gap, of course, I will call both the parties, and then using my skill, I will tell them ki koi baat nahi, let's settle with this middle figure. So in a way, of course, what am I doing? I'm negotiating, but with the consent of the parties. Okay. So of course, negotiation and mediation in a way interlinked and interdependent with with each other. You can't separate. You can't say that no, mediation is different and negotiation is different.
All right. Well, I'm also curious to know that has it ever happened to you that you're talking to someone or you are just generally having a conversation with any random person or your known person, and you have seen that people have misconceptions about ADR? And if yes, then what would be that misconception generally?
Well, when we talk ADR, the arbitration also kicks in. So are you, your question is on the arbitration, mediation, both,
In
or
total, in general,
exclusively
ADR.
on arbitration or mediation?
It's basically ADR, inclusive of every method.
See, for mediation, I told you that people think that it's a soft option. If the other party is approaching you for mediation, of course, they think that their case is weak. Why should I go? Dekha aage, line pe aa gaye, stuff like that. As far as arbitration is concerned, I don't see anything in the arbitration, any misconception. But people, I'll tell you what, it is not a misconception. A lot of people and a lot of client of mine who are proprietorship, who are running a proprietorship concerns, or which is a small company, I ask them to incorporate arbitration clauses in their dispute. And they tell me, ki, nahi ma'am, arbitration is very costly, which we read in our law school that it's not costly. It's time saving, it's cost saving.
Exactly.
I think that is a misconception. It's not cost saving. I'm sorry. It's not cost saving. It's actually, it is more expensive than, landing yourself in the court. In the court, in a recovery proceedings, what am I paying? I'm only paying 1% of the court fee, correct? Whereas in arbitration, I may end up in paying, especially, let's take an example of Schedule 5 only. I end up in paying, more than that. It is not 1% of the recovered amount in the schedule, which is there in the arbitration. And who is following the, schedule? Nobody. Let's be very honest. No arbitrator wants to follow Schedule 5, barring few. Otherwise, of course, it is a misconception that the people think that it's, we think that it's a cost saving. It's not cost saving. I'm sorry. It drains your resources.
Well, I think that is the opening of ground reality of ADR. Well, that's all with my questions. If you want,
but still I feel, Sahil, that this ADR is the best alternative to litigation. At least now your dispute in arbitration, at least you may be paying whatever you are supposed to under the statute, but at least you are getting a judgment within a period of a maximum span of 2 years. So yes, now it's a time saving exercise.
It's getting beneficial. Well, that's all with my questions. If you want to share any other experience or any opinion on any topic, subject matter related to ADR, feel free to do that. Otherwise, I'll be thanking you on behalf of the Institute for ADR. I extend my heartful gratitude.
It's a pleasure. It's a pleasure joining the this meeting, and I am thankful to you that you actually felt that I can be on the podcast.
It's a pleasure this side.
Thank you, Sai.
And with that, I would like to end the podcast. I would like to thank to the listeners as well. And I would like to convey that stay tuning in and never lose the thread of curiousness in yourself. That's all for today. Thanks a lot again, ma'am. And
thank you, Sahil.
That was a pleasant conversation. Thanks a lot.